all applicants' backgrounds will be measured against. It is from this benchmark that we will predict future performance and behavior based on the applicant's past performance and behavior in these areas and these areas alone. You take the applicants at face value when they provide data on their resume and in the interview. It is now time to verify that data. This is the last opportunity recruiters will have to reduce the risk before extending a formal letter of offer. Data verification. Checking references of prospective employees or giving references on former employees can result in defamation of character lawsuits if the data provided grossly misrepresents or provides unsubstantiated statements about the person on his or her performance. Contract laws. Canadian judges see employment contractually. If there is no written agreement between employer and employee, then their oral understanding is regarded as the basis of the employment contract. Many recruiters are still under the mistaken impression that they need a formal letter of offer to establish the employment contract. The act of hiring is the formation of a contract. Valid contracts give rise to rights and duties with legal consequences for both sides. Hiring creates a legal obligation even before the prospective employee has started the job. If either party breaches the contract in any way, the other party can sue for damages. Applicants may base their decision to quit their current job or stop their employment search based solely on the promises made by a recruiter. For this reason alone, recruiters must understand at least the fundamentals of contract law in all other acts and codes governing employer or employee relations. Employment standards. Employment standards are for those workers not governed by a collective agreement. Each province has their own version of employment standards. It is illegal to enter into any employment contract that gives prospective employees any less than these minimums. Labor relations. Discussing how job applicants feel about unions, or classifying resumes according to union beliefs, or offering opinions on what existing employees should do when a certification drive is going on, is a violation of the Labor Relations Act and can lead to fines, imprisonment, or automatic certification with no vote at all. In addition, a company's agency employees have the right to vote alongside the regular employees for purposes of collective bargaining. Health and safety. Workers who are hired and sent into an unsafe area without the proper safety equipment will result in huge company fines. There will be an investigation as to which individual was personally responsible, and criminal negligence charges will be laid. Workers' insurance. Employers who hire temporary help, casuals, and contractors on company premises will carry the full financial load in accident statistics if these people are not registered with their provincial office or do not carry private insurance. Human rights. Asking for discriminatory information on job applications or making hiring decisions on one of the discriminatory grounds will lead to punitive action and damage awards, and may even result in the person being offered the next available job in the company. Let's start off with data verification. We use this term instead of reference checks for an important reason. Conducting reference checks assumes that we will verify the references only supplied by the applicant, and anything beyond is a legal gray area to be avoided or requires special permission by the applicant. Frankly, recruiters will have to verify all the data provided by the applicant, whether it was on their resume or provided verbally in the interview process. Let's look at the reasons for verifying applicant data. Data verification helps to confirm all resume and interview points. Remember, up to this point, all we have is the applicant's word about what he or she has achieved in their work history. It's time to find out if the applicant keeps or loses the points previously assigned to his or her experience, skills, and behavior. With this approach, the applicant doesn't get the job because he or she had poor references. The person doesn't get the job because he or she no longer has enough points to remain in the competition. Data verification helps to avoid fraud. Resume fraud is on the rise in Canada. With fewer jobs available, competition has become fierce among job seekers. More than ever, employment experience and education credentials are critical to each applicant's chance of success. Applicants are coached to present themselves in the best possible light by focusing on their strengths and offsetting any deficiencies or past problems. In avoiding the high-risk hire, uncovering the problems is the key to making a successful hiring decision. Experts estimate that up to 1 in every 3 job applicants misrepresents themselves in some manner. These misrepresentations can take many forms. They can range from fudged employment dates that cover up a gap in employment, to a completely fictitious work history fabricated from defunct or non-existent companies. The most common misrepresentations involve embellishing or distorting the truth, providing selective details of employment history, or presenting false credentials. The sole motive of an applicant who commits resume fraud is to gain employment. Once an applicant has obtained employment, the motives may go beyond simply earning a living and include expense account fraud, inventory theft, kickbacks, check forgery, and time card fraud. Other examples may involve lost business or missed opportunities due to the employee's improper actions. Data verification helps to protect the employer. The employer is liable for the employee's actions. With civil litigation on the rise, negligent hiring has become a hot topic in North America. There is an obligation on the employer's part to provide a safe environment for employees and customers. This obligation has expanded beyond the traditional issues of equipment and the nature of the work to include the actions of coworkers and managers. There is an onus on the employer to conduct the necessary background checks on new employees to ensure they will not be a danger to other employees and customers or damage the employer's business reputation. Bad publicity from any of the above can often cause far greater long-term damage to the employer than any direct out-of-pocket costs. At first glance, obtaining employment references prior to hiring may appear to be a prudent way to safeguard the employer's business interests. Recently, the courts have, however, recognized that customers, fellow employees, and others who will interact with the referred employee in the new workplace may also be affected by the methodology of the reference process. These individuals are entitled to expect that all new employees have been sufficiently scrutinized in the hiring process, so that people dealing with them at work are physically, psychologically, and financially secure in their contact with him or her. Negligent hiring appears to have been recently adopted as a valid legal concept in the Ontario courts. Similarly, the failure of an employer to properly review references can result in the employer's liability to other employees in the organization for the acts of coworkers. There are some other legal issues surrounding data verification. Libel and slander. Libel is a written statement about an employee where the onus rests with the writer to prove that what was stated is in fact true. Slander is a verbal statement with the onus on the speaker to prove the statement is true. An organization can be sued for libel and slander by former employees because of negligent misrepresentations of their performance. Willful misrepresentation also includes providing good references for employees who failed in their job. A point of law for recruiters to understand is that no organization is legally obliged to furnish any references on any past or present employees. But when it does, it must be based on an honest assessment of the actual work performed and not on subjective impressions. Claims from other employers. Employers also face potential exposure to claims from new employers for giving references that either intentionally or negligently misrepresent the suitability of the candidate. Misrepresentation can be found as much in the sin of omission as it is in the sin of commission, as a half-truth may just as much be a false representation as a complete lie. While it may be tempting to comment favorably on employees' strengths and to completely ignore the employee's weaknesses, a much safer approach may be to say, at the very least, allude to the employee's weaknesses. Any job skill or personal suitability or compatibility issue directly relating to the position for which the applicant is being considered is material to the reference and requires full disclosure. In all cases, the employer should be very cautious before making comments that could be interpreted to warrant future performance. An employer who has hired an employee on the basis of a previous employer's negligent or fraudulent misrepresentation would be able to claim damages for the costs associated with the job competition, loss of profits attributable to the employee's performance or wrongful behavior, administrative costs, etc. Obligation to the job applicant. Employers should be aware of one legal requirement governing the use of employment references in the hiring process. Ontario's Consumer Reporting Act requires that employer who rejects a job candidate either wholly or in part because of a negative reference must inform the candidate that the reference influenced the decision to reject. The employer must also inform the candidate that he or she has 60 days to request the nature and the source of the reference information. The legislation does not go so far as to require that the rejected applicant be given an actual copy of the reference if the reference is in written form. To date, no employer has been prosecuted for failing to inform rejected job applicants of negative references regarding their previous employment. In all likelihood, this is because most job candidates are not aware of their rights under the Act. The Act allows for substantial penalties of up to $25,000 or imprisonment for a period of up to 1 year or both. For candidates applying for jobs in the federal sector, the Privacy Act gives job applicants the right to access any personal data about them contained in the Personal Information Bank, such as an employment reference in a personnel file. The Act also allows access to other information within the control of a government institution, if the applicant can supply specific information to permit the requested information to be searched. The job competition number with the date of the competition should allow an employment reference held on a competition file to be traced. Unlike the similar provincial legislation, the Privacy Act does not grant to any organization any discretion to refuse access to reference information. Refusal to provide references. Another legal vulnerability occurs when an employee is dismissed. If he or she was dismissed for cause, an employer must be careful that any reference they give does not affect the ability to establish just cause before a court. In other words, don't give references to employees who are dismissed for cause. If the dismissal was without cause, the employer is required to provide reasonable notice for payment in lieu of notice. Reasonable notice is based upon the time it will take to find another job. An employer's refusal to provide a reference may lead to increases in both notice and compensation or an award of punitive damages where the refusal is not justified. Although there is no legal duty to provide references, the courts have not looked favorably upon employers who refuse to do so. Where an employee has been dismissed and no cause is alleged for the dismissal, it is in the interest of both the employer and the employee that the individual be reemployed as quickly as possible, so as to mitigate any claim for damages for wrongful dismissal. Where there exists dismissal for just cause, the situation is more problematic. As in the case of employee termination, the employee is expected to become reemployed as quickly as possible. However, without a reference from the most recent employer, the employee is stymied in his or her attempts to do so. The employer may find itself in a damned if you do and damned if you don't situation. If the employer provides a negative reference or none at all, it risks judicial sanction for making it difficult for the employee to fulfill his or her duty to mitigate. The courts have penalized employers by forcing the employer to pay a larger slice of the successful employee's legal costs by awarding punitive damages or by extending the period of notice considerably beyond that which would normally be recovered by an employee in a similar position. With this legal quagmire in place, there will still be a strong temptation to minimize such risks by refusing to give references. However, given the genuine benefits for all prospective employers when references are freely exchanged, a better approach would appear to be for the employer to actively develop an understanding of the risks associated with the reference process and to prepare an appropriate reference policy so as to minimize those risks. First, look at 3 topics associated with data verification. Personal. Simply don't bother. Applicants providing letters from family, friends, clergy, school administrators, etc. have no bearing on directly observed work performance. To seek out or request this information is a waste of time. Academic. Unless you are specifically looking for a diploma or certificate, waste no time here either. Tracking down previous school records or waiting for transcripts for a position requiring little or no education is also a waste of time. But if you do require certification, make sure you obtain the original document or notarized transcripts before the new hire starts the job, because copies can be doctored easily with today's desktop publishing software. Business. This should be the main area of focus for the recruiter. This is the data that will be measured against the job description benchmark and where the prediction of future performance will be made. This is the area where immediate supervisors have directly observed both performance and fit, and have, or should have, documented the details in ongoing performance appraisals. This data is the most valuable, and anything else will not reduce the risk of hiring the wrong person. Now let's look at some research done on gathering reference data. Ensure data reliability. Studies indicate that references are more reliable if the supplier was the immediate supervisor and had more than 2 months to observe the applicant's performance and behavior. References from personal or human resource departments are secondhand and may be considered hearsay, unless they are reading the supervisor's notes from the appraisal document. Ensure data relevancy. Ensuring reference accuracy requires asking very specific questions about the applicant's previous performance in the areas specific to the available job. If the applicant was a file clerk in a previous position and the available job requires him or her to conduct a customer survey, then asking the past supervisor for a reference is a waste of time. When the supplier tries to guess how this individual would perform in a data entry function, problems of opinionated, subjective, and perhaps slanderous statements may surface. Ensure data consistency. Another important point for the recruiter is to gather references from many sources and look for consistency in their evaluations. Personality conflicts with previous supervisors are a fact. When more than one reference supplier indicates that the applicant has had these conflicts, then the information can be considered valuable. Here are a few steps to take to ensure that you're headed in the right direction when you verify a job applicant's history. This is the first line of defense against resume fraud and a deterrent to any possible misrepresentation before it has occurred. Verify only the applicant you intend to hire. Why spend time and money investigating all the competitors' backgrounds? Start with the applicant you intend to hire. If that doesn't work out for any reason, proceed to the next applicant. Remember, you want this data to decide whether the successful applicant keeps or loses their points. Gathering data on many applicants before making the selection decision puts that decision in the hands of the reference supplier. You make the decision. Caution the applicant. Let the candidate know early in the recruiting process that the information provided both verbally and in writing will be verified for accuracy. This will help produce honest and factually correct information right from the start. This can be in the form of a waiver whereby the applicant consents to a verification process and certifies the information they provide is correct to the best of their knowledge. Use an application form. A great deal of resume fraud is facilitated by poor resume format. When an applicant's resume is relied on exclusively for employment and education history, the risk of misrepresenting details and receiving only selective details increases dramatically. By implementing a policy that requires all applicants to complete a structured application form, there is greater control over the completeness and accuracy of the information that is collected. Verify all the details and follow up. While these procedures will dramatically reduce white lie resume fraud, it is even more important to implement procedures to detect the far more dangerous applicant whose clear intent is to deceive. Follow through on all verification. The threat of checking references and verifying details can only yield partial success. In order to have a truly effective hiring process, complete background verification must be completed to ensure the hiring decision will be based entirely on the truth. Be persistent and don't give up too easily. If you are unable to obtain complete details from a company due to its policy, recruit the applicant's assistance. Ask for names of individuals within the firm willing to provide a reference or from others who have left the company. Remember to take into account their relevance and impartiality. Identify gaps in employment and missing details. Gaps in employment are normal and on their own are not causes for concern. A problem occurs when a gap is a result of an omission rather than legitimate reasons such as a period of unemployment, travel, or child care leave. When conducting the initial applicant interview, be sure to obtain precise dates of employment and identify the reasons for all significant employment gaps. Also, ask former employees the reason for the applicant's termination and whether they know the applicant's subsequent employer, if they were not the most recent. Look for balance. No person is either all bad or all good. Beware of data from suppliers who portray former employees this way. This is a sure sign that subjectivity is rampant. Regardless of how badly an employee performed, there must be things that he or she did well. Look for them in both instances. The courts are very sensitized to this issue of balance. use a standard verification format. Many employers regularly provide references, however they aren't required by law to do so. The courts do recognize that the free flow of information between employers would be greatly hampered if there were fear of defamation action. Therefore, it's a requirement that the reference only be provided in good faith. References come in a multitude of shapes and sizes. They may be presented in writing or verbally. If written, they may take the to whom it may concern approach, or be forwarded specifically to a particular addressee. No matter what the format, every reference given must present an accurate and balanced picture of the referred employee. The reference should also be consistent with the employee's performance and evaluations that were conducted while the employee was with the former employer. This approach protects the interests of the three main parties involved in every reference situation: the prospective employee's interests in being able to properly evaluate the suitability and skills of job candidates, the employee's interest in protecting his or her reputation, and the ex-employee's interest in avoiding legal action by a new employer for the negligent misrepresentation of the ex-employee's job-related performance or personality, or from the ex-employee for libel or slander where false and detrimental statements were made. For the following, please refer to the Data Verification Form handout. This format will capture everything you need to know about an applicant. You'll immediately see three distinct advantages for using it. First, it provides consistency. Asking these same questions to all data suppliers ensures that you don't forget to ask an important question about an applicant. With the laws protecting personal information, this is an area that recruiters and other data verifiers in your organization want to approach with care and implement with rigid consistency. Second, more likely to get data. You'll notice that the form contains responses in a sliding scale. Data suppliers will be more likely to furnish a number rather than a long subjective statement that you'll be forced to record. You don't want to do this for the same reasons you don't want to take interview notes. If a data supplier tells you that Mr. Jones is a 2 for arrived on time, then you have all you need to know. You really don't want to know more than this. A 2 tells you the story without getting into murky legal waters. Next, easy to spot trends. Does it really matter whether the score is 1, 2, or 3 for any question? Not really. These low numbers generally indicate a problem. Look at the numbers within the form and compare them to the numbers of the various data suppliers. Then look for trends. It focuses applicants on required data. Frankly, nowhere is it written that you have to spend extensive time tracking down all this data. Get the applicant to provide the data for you. He or she has access to their previous performance evaluations through access to information laws, where this data must be made available to employees and ex-employees. You do not have access to this information because of privacy laws, but the applicant has. Ask the applicant to provide you with copies of their past 3 or 4 appraisals, or failing that, give the applicant a copy of the data verification form and have him or her have it filled out by their previous supervisors or managers. Make sure you get a name and telephone number of the data supplier so you can verify it wasn't filled out by the applicant. It can be used for departing employees. Why not use the form for your own departing employees? Have their immediate manager or supervisor complete the form the same way you're requesting of other employers. In this way, when a future employer calls for data verification on that former employee, you can simply provide a copy of the form. Call them mini departing appraisals and include this document with the other data you hold on ex-employees. This is preferable over having your manager supply verbal data on the phone that may be libelous or slanderous. Consider this. A prospective employer may ask whatever questions he or she wants about a future employee, but no employer is legally required to answer the questions. If an employer does answer the questions, however, he or she had better make sure the information is accurate. When information is given, so long as it is given with reasonable care and in good faith, there is nothing to worry about. This is the reason for performance appraisals. The Act in brief. Organizations must obtain an individual's consent when they collect, use, or disclose the individual's personal information. The individual has a right to access personal information held by an organization and to challenge its accuracy, if need be. Personal information can only be used for the purposes for which it was collected. If an organization is going to use it for another purpose, consent must be obtained again. Individuals should also be assured that their information will be protected by specific safeguards, including measures such as locked cabinets, computer passwords, or encryption. Personal information. Personal information includes any factual or subjective information, recorded or not, about an identifiable individual. This includes information in any form such as age, name, ID numbers, income, ethnic origin or blood type, opinions, evaluations, comments, social status, or disciplinary actions, employee files, credit records, loan records, medical records, existence of a dispute. Personal information does not include the name, title, business address, or telephone number of an employee of an organization. Offenses. It is an offense to destroy personal information that an individual has requested. It is an offense to retaliate against an employee who has officially complained. It is an offense to obstruct a complaint investigation or an audit by the Privacy Commissioner or his delegate. A person is liable to a fine of up to $10,000 on summary conviction or up to $100,000 for indictable offenses. Obtain consent. Your responsibilities include to inform the individual in a meaningful way of the purposes for the collection, use, or disclosure of personal data. You have the responsibility to obtain consent from the individual whose personal information is collected, used, or disclosed. You have the responsibility to communicate in a manner that is clear and can be reasonably understood. You must record the consent received, for example, note to file, copy of email, copy of checkoff box, etc. The consent can be obtained in person, by phone, by mail, by the internet, etc. Never obtain consent by deceptive means. Explain to individuals the implications of withdrawing their consent. Express consent should be used whenever possible in all cases when the personal information is considered sensitive. Relying on express consent protects both parties. Give individuals access. Your responsibilities. When requested, inform individuals if you have any personal information about them. Explain how it is or how it has been used, and provide a list of any organizations to which it has been disclosed. Give individuals access to their personal information. Correct or amend any personal information if its accuracy and completeness is challenged and found to be deficient. Provide a copy of the information requested or reasons for not providing access. Respond to the request as quickly as possible and no later than 30 days after receipt of the request. Give access at minimal or no cost to the individual. Some exceptions to access. Organizations must refuse an individual access to personal information if it would reveal personal information about another individual unless there is consent or a life-threatening situation. If this information can be removed, the organization must release the remaining information. Organizations can refuse if the organization has disclosed information to a government institution for law enforcement or national security reasons. Upon request, the government institution may instruct the organization to refuse access or not to reveal that the information has been released. The organization must refuse the request and notify the Privacy Commissioner. The organization cannot inform the individual of the disclosure to the government institution, or that the institution was notified of the request, or that the Privacy Commissioner was notified of the refusal. Organizations may refuse access to personal information if the information falls under one of the following: solicitor-client privilege, confidential commercial information, disclosure could harm an individual's life or security, it was collected without the individual's knowledge or consent to ensure its availability and accuracy, and the collection was required to investigate a breach of an agreement or contravention of a federal or provincial law. In this case, the Privacy Commissioner must be notified. Or it was generated in the course of a formal dispute resolution. If any of this information can be removed, then the organization must release the remaining information. Employment contracts can be written or oral. Often, many of the terms in employment contracts are never expressly stated in any form, but are implied from the act of the parties and their common understanding of the circumstances and from the court's perception of what the parties' rights and obligations ought to be as a matter of public policy. Canadian judges tend to give the benefit of the doubt to the employee because it is assumed that the employee is in a more vulnerable position. Here are the terms. Implied terms. Implied terms are terms, although not expressly stated, that are regarded as terms of the contract. 1. Based on the basic operation of the law. 2. Past practices of the company. 3. Terms of the contract deemed to be agreed upon by the conduct of the two parties. Employment contracts are seen as being more fluid than administrative contracts. Expressed terms. 1. Form. The terms of the contract are determined by the conduct of the parties during the term of employment, not by conscious negotiation and agreement. 2. Awareness. The employee must be aware of the content of the contract and that the terms apply to him or her. 3. Voluntariness. Courts will not enforce a contract not voluntarily agreed to by the employee. There must be no duress and clauses must be clear and unambiguous. 4. Content. Terms must be legal. Terms must not be excessively harsh. The terms of the contract must continue in effect. The existing contract stays in effect until a new one is agreed to. Look at the types of employment contracts. There are two: definite and indefinite contracts. Indefinite means that there is no foreseeable end to the employee's service and it could conceivably terminate with retirement or death. A definite contract has a specific beginning and end. Most organizations hire contractors, which are really definite contracts, and try to save money by not paying perks and benefits, and with the hope of a quick dismissal at any time without penalty. But these same organizations extend these contracts, and this means they become indefinite contract employees, and they can sue for whatever they didn't get as an indefinite employee. In other words, they will be treated as full-time salaried personnel. Here's what Revenue Canada has to say on the matter. Are they employees or independent contractors? The determination of whether an individual is an employee or an independent contractor for tax purposes is important for several reasons. Wages paid to employees generally are subject to employment taxes, and only wages paid to employees are used to calculate unemployment benefits. Service performed by an individual for payment is employment unless an employer can show that the employer-employee relationship does not exist. In determining the existence of the independent contractor relationship, the common law of agency right to control shall be applied. If the employer retains the right to control the manner and means by which the results are to be accomplished, the individual who performs the service is an employee. If only the results are controlled, the individual performing the service is an independent contractor. To help determine whether an individual is an employee under the common law rules, 20 factors have been identified which are used as guidelines to determine whether sufficient control is present to establish an employer-employee relationship. These factors should be considered guidelines. Not every factor is applicable to every situation, and the degree of importance of each factor varies depending on the type of work and individual circumstance. However, all relevant factors, including any relevant previous court decisions, are considered in making a determination. No one factor is decisive. The 20 factors indicating whether an individual is an employee or an independent contractor are: 1. Instructions. An employee must comply with instructions about when, where, and how to work. Even if no instructions are given, the control factor is present if the employer has the right to control how the work results are achieved. 2. Training. An employee may be trained to perform services in a particular manner. Independent contractors ordinarily use their own methods and receive no training from the purchasers of their services. 3. Integration. An employee's services are usually integrated into the business operations because the services are important to the success or continuation of the business. This shows that the employee is subject to direction and control. 4. Services rendered personally. An employee renders services personally. This shows that the employer is interested in the methods as well as the results. 5. Hiring assistants. An employee works for an employer who hires, supervises, and pays workers. An independent contractor can hire, supervise, and pay assistants under a contract that requires him or her to provide materials and labor and to be responsible for only the result. 6. Continuing relationship. An employee will generally have a continuing relationship with an employer. A continuing relationship may exist even if work is performed at recurring, although irregular intervals. 7. Set hours of work. An employee usually has set hours of work established by an employer. An independent contractor generally can set his or her own work hours. 8. Full-time required. An employee may be required to work or be available full-time. This indicates control by the employer. An independent contractor can work when and for whom he chooses. 9. Work done on premises. An employee usually works on the premises of an employer. 10. Order or sequence set. An employee may be required to perform services in the order or sequence set by an employer. This shows that the employee is subject to the direction and control of the employer. 11. Reports. An employee may be required to submit reports to an employer. This shows that the employer maintains a degree of control. Payments. An employee is paid by the hour, week, or month. An independent contractor is usually paid by the job or on a straight commission. 13. Expenses. An employee's business and travel expenses are generally paid by an employer. This shows that the employee is subject to regulation and control. 14. Tools and materials. An employee is normally furnished significant tools, materials, and other equipment by an employer. 15. Investment. An independent contractor has a significant investment in the facilities or equipment he or she uses in performing services for someone else. 16. Profit or loss. An independent contractor can make a profit or suffer a loss. 17. Works for more than one person or firm. An independent contractor is generally free to provide his or her services to two or more unrelated persons or firms at the same time. 18. Offers services to general public. An independent contractor makes his or her services available to the general public. 19. Right to fire. An employee can be fired by an employer. An independent contractor cannot be fired so long as he or she produces a result that meets the specifications of the contract. 20. Right to quit. An employee can quit his or her job at any time without incurring liability. An independent contractor usually agrees to complete a specific job and is responsible for its satisfactory completion, or is legally obligated to make good for failure to complete it.